Welcome to EPG Pathshala. This is Dolika Jyoti Sharma from the Department of English, Guwahati University. Today we will do paper 13 and module 22 of that paper. The module is titled Convention on the Elimination of All Forms of Discrimination Against Women, in short named Cedaw. In this unit, we will try to look at the theoretical dimensions of women and conflict and try to develop an understanding of the gendered nature of conflict. We will also try to look at gender as a comprehensive and interdisciplinary analytical tool. Equal rights for both men and women is the core principle of the United Nations. The International Bill of Human Rights, which is the UN General Assembly Resolution 217A(3), reinforces and extends the fundamental rights of women. The preamble of the Charter of the United Nations sets as one of the organization's central goals the reaffirmation of faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women. Article 1 proclaims that one of the purposes of the United Nations is to achieve international cooperation in promoting and encouraging a respect for human rights and for fundamental freedoms for all without distinction, including, among other things, sex. By terms of the Charter, the first international instrument to refer specifically to human rights and to the equal rights of men and women, all members of the United Nations are legally bound to strive towards the full realization of all human rights and fundamental freedoms. The status of human rights, including the goal of equality between women and men, is thereby elevated. A matter of ethics becomes a contractual obligation of all governments and of the UN. The Universal Declaration of Human Rights of the UN extends to all people equal status in the eyes of the law and assures the enjoyment of fundamental rights for all human beings. There is to be no discrimination on the basis of religion, race, or nationality, and specifically not on the basis of sex. The 1966 International Covenant on Economic, Social, and Cultural Rights and the International Covenant on Civil and Political Rights puts these rights into legal terms so that they would be binding on all member countries. Special stress during these times was put on particularly those countries that have ratified the covenants. Unfortunately, women in many parts of the world were and still are denied these rights. It has fallen upon the Commission on the Status of Women, in short known as CSW, to clarify and define these guarantees of their fundamental rights. Several significant conventions related to women's human rights have been declared. If we look at the history of this concern for women and their fundamental rights, we can look at the CWS. The CWS was first established in 1946 as a sub-commission of the Human Rights Commission, But it was soon realized that a full commission was required to address the situation and specific problems of women, and it was elevated from a sub-commission to a full commission. So what happens here is that the ethical look at human rights, in this case, it focuses itself particularly on women's rights. The responsibility of the CWS was to recommend possible solutions to pressing problems of women and to create proposals that would facilitate the implementations of these recommendations made. So, consequent to that, during the period 1949 to 1959, that is not consequent to but prior to this period, during the period 1949 to 1959, that is the decade immediately before this particular resolution took place, the Commission expanded the following commissions. First, the Convention on the Political Rights of Women, adopted by the General Assembly on 20th December 1952. Second, the Convention on the Nationality of Married Women, adopted by the Assembly on 29 January 1957. Third, the Convention on Consent to Marriage, Minimum Age for Marriage and the Registration of Marriages, adopted on 7th November 1962. And finally, the Recommendation on Consent to Marriage, Minimum Age for Marriage and Registration of Marriages, adopted again on 1st November 1965. However, though these recommendations were comprehensive in nature and covered those areas where the human rights of women were specially compromised, they could not address the problems in any effective manner. Therefore, given these problems, the General Assembly on 5th December 1963 adopted its Resolution 1921-18, in which it requested the Economic and Social Council to invite the CSW to prepare a draft declaration that would combine in a single instrument international standards articulating the equal rights of men and women. This process was supported throughout by women activists within and outside the UN system. The drafting of the declaration by a committee selected from within the CSW began in 1965, with the Declaration on the Elimination of Discrimination against Women ultimately being adopted by the General Assembly on 7 November 1967. Although the declaration amounted only to a statement of moral and political intent without the contractual force of a treaty, its drafting was nonetheless a difficult process. Article 6 concerning equality in marriage and the family and Article 10 relating to employment proved to be particularly controversial, as did the question of whether the declaration should call for the abolition of the customs and laws perpetuating discrimination or for their modification or change. The 1960s saw the emergence in many parts of the world of a new consciousness of the patterns of discrimination against women and a rise in the number of organizations committed to combating the effect of such discrimination. The 1960s, if we go back to look at the context of that period, the 1960s was also a period where several other protests or movements began, the civil rights movement, for example, or the anti-war movement, because if we remember, the 1960s was also marked by the very controversial Vietnam War. The 1960s also marks the emergence of a second wave of feminism, and this in a way can be related to all these changes of policies, or at least the concern regarding the necessity to change or ratify certain policies of the United Nations. The adverse impact of some development policies on women in particular also became apparent during this period. In 1972, 5 years after the adoption of the Declaration and 4 years after the introduction of a voluntary reporting system on the implementation of the Declaration by the Economic and Social Commission, the CSW considered the possibility of preparing a binding treaty that would give normative force to the provisions of the Declaration, and decided to request the Secretary General to call upon UN member states to transmit their views on such a proposal. The following year, that is in 1973, a working group was appointed to consider the elaboration of such a convention. The next year, in 1974, at its 25th session, and in the light of the report of this working group, the Commission decided in principle to prepare a single, comprehensive and internationally binding instrument to eliminate discrimination against women. This instrument was to be prepared without prejudice to any future recommendations that might be made by the United Nations or its specialized agencies with respect to the preparation of legal instruments to eliminate discrimination in specific fields. So, what happens here is that this particular declaration is made, this instrument rather, is made with a certain kind of foresight in mind, so that it blends very well with future policy decisions made by the UN. The text of the Convention on the Elimination of All Forms of Discrimination Against Women was prepared by working groups within the Commission during 1976, and extensive deliberations by a working group of the Third Committee of the General Assembly from 1977 to 1979. Drafting work within the Commission was encouraged by the World Plan of Action for the Implementation of the Objectives of the International Women's Year, adopted by the World Conference of the International Women's Year held in Mexico City in 1975, which called for a convention on the elimination of discrimination against women, with effective procedures for its implementation. Work was also encouraged by the General Assembly, which had urged the Commission on the Status of Women to finish its work by 1976, so that the convention would be completed in time for the 1980 Copenhagen Mid-Decade Review Conference, that is, the World Conference on the United Nations Decade for Women, Equality, Development and Peace. Although suggestions were made to delay completion of the text for another year, the Convention on the Elimination of All Forms of Discrimination Against Women, or the Cedaw, was adopted by the General Assembly in 1979 by votes of 130 to none, with 10 abstentions. In Resolution 34-180, in which the General Assembly adopted the Convention, the Assembly expressed the hope that the Convention would come into force at an early date and requested the Secretary General to present the text of the Convention to the Mid-Decade World Conference of the United Nations Decade for Women. So we can see how there was an overwhelming support for the Cedaw within the United Nations. Now, at the special ceremony that took place at the Copenhagen Conference on 17 July 1980, 64 states signed the convention and 2 states submitted their instruments of ratification. On 3rd September 1981, 30 days after the 20th member state had ratified it, the convention entered into force, faster than any previous human rights convention had ever been able to, thus bringing to a climax United Nations efforts to codify comprehensively international legal standards for women. The Cedaw was adopted by the UN General Assembly in 1979. It is described as an international bill of rights for women. The preamble of the convention recognizes that even now, extensive discrimination against women continues to exist as an obstacle to the participation of women on equal terms with men in the political, social, economic and cultural life of their countries. It also states its awareness of the need for a change in the traditionally assigned roles of men and women to attain complete equality between them. The Committee on the Elimination of Discrimination against Women comprises 23 independent experts on women's issues that monitors the implementation of this committee. It monitors the progress and the development of those countries that are state parties to the 1979 Cedaw. The convention thereby focuses on the human rights of women, firstly, and it, secondly, prepares a plan of action by member countries to ensure the same fundamental rights and freedom as men enjoy. The convention recognizes in its preamble the widespread discrimination and violation against women worldwide. The central focus of the convention is thereby on equality. The convention covers this particular aspect in all the areas, that is civil, legal, political and reproductive aspects and rights of women. The 30 provisions in the convention attempt to cover every possible aspect of a woman's life. The first article of the convention defines and acknowledges the meaning of the term of discrimination against women. That is, what does it mean to talk about discrimination against women? What is discrimination against women? It says that discrimination against women shall mean any distinction, exclusion or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil or any other field. The second article appeals to the states to take serious steps to eliminate all forms of discrimination against women and to ensure their equality with men. It seeks to adopt appropriate legislations or sanctions wherever appropriate that prohibits discrimination against women. It also tries to ascertain the equal legal protection of the rights of women with men and reinforce it through national tribunals and awareness programs. And thirdly, it tries to take stringent measures to abolish any law, customs and regulations that might lead to discrimination against women. The third article is on the obligations of states regarding the fundamental human rights of women. It says that the state parties shall take in all fields, in particular in the political, social, economic and cultural fields, all appropriate measures including legislation to ensure the full development and advancement of women for the purpose of guaranteeing them the exercise and enjoyment of human rights and fundamental freedoms on a basis of equality with men. The fourth article talks about the short-term or the temporary measures used for this. It states that the adoption by states parties of temporary special measures aimed at accelerating the de facto equality between men and women shall not be considered discrimination as defined in the present convention, but shall in no way entail as a consequence the maintenance of unequal or separate standards. These measures shall be discontinued when the objectives of equality of opportunity and treatment have been achieved. The adoption by state parties of special measures, including those measures contained in the present convention aimed at protecting maternity, shall not be considered discriminatory. This particular article provides a certain kind of qualification to the general tenor of the convention. Now, Article 5 of the convention specifically asks states to improve the cultural practices that limit a woman's opportunities and eliminate prejudices against her. since different cultures have different strictures against women, which is why this convention seeks to, in a way, encompass or embrace all these differences of women's experience as far as their cultural backgrounds or contexts are concerned. The 6th article of the convention calls for states to have legislations to stop trafficking of women and put in place stringent regulations that ensure that they are not exploited. Articles 7 and 8 specifically focus on the political rights of both men and women. They appeal to state authorities to involve women in developmental policies and develop measures to let women represent the governments in international organizations. So these 2 articles are more about the political representation of women in both national and particularly in international circles. Article 10 provides for the promotion of equality to both men and women in the field of education. It seeks to make efforts to eliminate gender stereotypes. Article 11 requests the state authorities to eliminate discriminatory policies in employment. It requests the state to introduce maternity leave with pay. Article 12 requests the state to provide women appropriate services during pregnancy and post-childbirth. In fact, in India, we can see how these aspects of the convention are reflected. For example, in the 6-month maternity leave that the government guarantees or the government provides, and the kind of projects and the various projects, the policies regarding childbirth and post-delivery health care for the women as well as the child. Article 13 asks the states to ensure equal rights to family benefits and the right to bank loans and other specific financial assistance. Article 14 gives special consideration to the problems faced by women and acknowledges their roles in the economic survival of the families. It appeals to the state to encourage women to participate in the implementation of development policies. Article 15 of the Convention gives special attention to the equality between men and women before law. The provision requests the state to denounce laws and regulations that restrict the legal rights of women. Article 16 emphasizes the significance of marital rights of women and seeks to eliminate discrimination within marital relationships. This particular article also requests the state to grant the right to women to freely choose their partners and to decide whether they want to marry. The convention also emphasizes women's right to family planning, thereby emphasizing the fact that women also need to be in control of their own bodies. The achievements of the Cedaw include international appreciation and recognition of women's rights as human rights, the creation of national apparatus for the advancement of women, the collection of sex disaggregated data by states parties, the promotion of women's political participation, the passing of specific domestic violence legislations, as well as intersectionality, considering the different requirements of women in different cultural, social, or economic subgroups as entailing special attention and mention, amongst others, women in poverty, women from minority communities, women with disabilities, refugees, migrants, stateless and homeless women, women from the lesbian community, and aged women. So, the achievement of the Cedaw in this particular aspect is to, in a way, bring about a comprehensive sensitization to women belonging to various disparate groups. The Cedaw's tools to attend to cultural, social, and economic intersectional differences between women are a branch of the core right to equality and are not a vehicle for its fragmentation. In this respect, Cedaw is in consonance with all the fundamental concepts of today's feminisms. And that is, in a way, another achievement of this particular convention. Now, when we look at the ratification of the Cedaw, particularly in the Indian context, we will find that India ratified the Cedaw in July 1993. However, the country made two declarations regarding the convention. The first was in regard to 5A of the convention, about which the government declared that, quote, "It shall abide by and ensure these provisions in conformity with its policy of non-interference in the personal affairs of any community without its initiative and consent," unquote. We can find the relevance of this particular declaration in the fact that there are various communities, whether religious or other, which have different insights, different frames of laws regarding various social functions, various social activities, and in particular marriage. The second declaration regarding 16(2) of the convention stated that the government of the Republic of India declares that though in principle it fully supports the principle of compulsory registrations of marriages, it is not practical in a vast country like India, with its variety of customs, religions, and level of literacy. The Netherlands noted that these declarations were, quote, "incompatible with the object and purpose of the convention." Therefore, India does not comply with regular reporting, and several reports due to be submitted to the supervisory committees therefore remain outstanding. So in India, there's a kind of mixed response, as it were, mixed involvement of the government of India. Finally, a reservation that India makes states that they will not submit to arbitration if there is a dispute of Cedaw. Thus, India had reservations about Cedaw and appears to have ratified only half-heartedly. In an article on the Cedaw by Bobby Khanna in EUW Bothwell Policy Journal in 2013, Khanna states that the ratification of Cedaw by India did not reduce violence against women because the international agreement was not legally implemented. So the problem in India here is that the Cedaw, even though it exists in principle, it does not have a legal status as such. It is a fact that women and girls in this country face discrimination and violence at many levels. Women are burned for dowry, female feticide is rampant, thousands of girls are abducted annually and forced into prostitution. We can see that in Assam, for example, where there are a number of cases of human trafficking, especially of women. Although there are many laws and organizations for the protection of women and girls, the laws do not appear to be effective and serve as laws only on paper. The culturally embedded preference for sons directly impacts on the existence and nurturance of girls. There are several reasons why the preference for sons is so strong. Tradition and culture in India put the responsibility of care of parents in old age upon the sons. The last rites are also performed by them. The boy in the family carries on the family name while the girl gets married, and through her dowry is a drain on the wealth of the family. Therefore, parents like to spend less on their daughters, seeing them more in terms of a burden or what is called paraya dhan, somebody else's wealth. In the cycle thus established, girls are less educated, therefore, and since they are less educated, they do not earn as much and are unable to do for their parents what their brothers can. With more girls educated, old patterns are changing, albeit very slowly. It will be a few generations before change will filter down to all parts of the country. In the meantime, as of now, the preference for sons continues and daughters continue to be devalued in our society. At the ground level, thereby we can see that the Cedaw has not really impacted on the lives of Indian people, especially Indian women and girls. The convention emphasizes eliminating discrimination in the field of education, economic and social life, and talks about equality before law. But the population of India is not only large but also very diverse, with a big section living in the rural areas, a declining sex ratio, marked differences in incomes. All these act as a hindrance to the benefits of development reaching women. They also make implementation of the convention difficult to carry out. In the absence of a proper and compulsory registration of births, marriages, child marriage and trafficking also go on with impunity. So, in conclusion, we can see that though the Cedaw is really, in theory, a very effective convention to ensure that women get their share of their rights and freedom. In the case of India, we find that we have to take this convention with certain reservations, primarily due to the fact that the government here has still refused to give it a legal credibility as such. Which is why even after the Cedaw, even decades after the Cedaw has been in function in theory, development and freedom, fundamental rights for women have still relatively taken a back seat. Thank you.